Okay. Very good evening to all the participants and good afternoon to Mr. Gautam Bhatia.
Thank you.
He has joined from UK, so it's afternoon there. So very warm welcome, Mr. Gautam Bhatia. Uh,
Thank you so much.
we are celebrating this 71st Constitution Day. On this day, Constitution of India was adopted, and to commemorate the adoption of Constitution of India, every year we celebrate Constitution Day. This year we are having this program organized by High Court of Jammu and Kashmir, and Mr. Gautam Bhatia would be talking to us on the very pertinent subject, which is very current topic also, Preamble of the Constitution of India and the idea of inclusion. Just I'll give brief introduction of Mr. Bhatia before I'll request Mr. Bhatia to start the deliberations in this session. Mr. Bhatia is a law graduate from National Law School of India, University Bangalore. He completed his LLB in the year 2011. He did his BCL in 2012 from Balliol College, University of Oxford with distinction. He completed his MPhil in law in 2013 from the same college, University of Oxford. Then he completed LLM from Yale Law School in the year 2014, and presently Mr. Bhatia is doing his DPhil in law from Oxford University. He had joined uh, this uh, DPhil course in the year 2018 and is expected to complete it by July 2021. During his studies at National Law School, he was quarter finalist at the 51st Philip C. Jessup International Law Moot Court competition in the year 2009-10, organized by International Law Students Association. He has been conferred with awards and scholarship like Rhodes Scholarships in the year 2011, Herbert Hart's Prize for writing the best essays in the Jurisprudence and Political Theory examination, awarded by Faculty of Law, University of Oxford in 2012, the New India Fellowship in 2017 for writing a monograph titled The Transformative Construction, the Clarendon Scholarship in 2018 and 20, and awarded the Modern Law Review Scholarship in 2021. He has held many academic positions at many institutes of eminence. Mr. Bhatia has to his credit many publications, books, articles. Among his books, The Transformative Constitution, a radical biography in 9 acts, published by HarperCollins in the year 2019, and Offend, Shock and Disturb Free Speech under the Indian Constitution in the year 2015 are the prominent works. Mr. Bhatia has conducted many lectures and conferences, and he is presently doing a series of lectures on landmark judgments of the Supreme Court of India. Mr. Bhatia is also involved in legal research and writing in and outside India. So Mr. Bhatia has many things to his credit, and if I start reading his full bio, it would consume half of my program. So to cut short that, I have already circulated Mr. Bhatia's CV, so you'll be benefited by reading this. So welcome, Mr. Bhatia, and I'll request you to start the deliberations in the today's topic. Please.
Thank you. Thank you so much for that very generous and warm introduction. My apologies. I had some connectivity issues, so I was struggling for about 10 minutes to join, and finally I've come in from my phone. So, if you can see some lighting issues and things, it's I'm coming in on my phone, so that's a bit of a problem. But I hope it wouldn't affect anything beyond that. And so this actually, it's very interesting that we are having this Constitution Day celebration, and because I just read 2 or 3 days ago that the Oxford Dictionary has this. Every year they have one word of the year that they pick from each language, based on the events that have taken place that year and the importance of that word. And in fact, this year from Hindi they've picked Samvidhan, which means constitution. So this year the word of the year in Hindi is the word Samvidhan, which actually stands for the Constitution. So I thought that was really interesting that we are here on Constitution Day, and the importance of this word has really come to the fore in recent times. And in fact, I thought that very fact that the word Samvidhan, which is in the Hindi for Constitution, has been chosen as word of the year is an interesting point of departure to think through. I think some of the important topics that have been pertinent in recent months. So if you look at the word Samvidhan, what you find is that the root word of Samvidhan is the word Vidhan, and the cognate of it, which is the word Vidhi, from which Vidhan comes. Uh, that word in Hindi means, among other things, it refers to a path or a way that you need to take to accomplish something. Those of you who grew up with Hindi as your language will know that that's what the word Vidhi actually means, and that is where Samvidhan or Constitution comes from. So the constitution, when we think of it in terms of vidhan or as vidhi, what it's telling us is that no matter how important or how desirable the goal or the purpose is, there must also be a way that you have to follow to get to that goal. So you can't just do anything that you want to achieve the goal. There has to be a set path to get to that goal, and that path is as important as the goal itself. And that path is marked and defined by certain signposts which show what that path is. And those signposts are certain values or principles. And those values or principles are set out in a document like the preamble. So it's now obviously the preamble, unlike the fundamental rights chapter, is not directly enforceable. So you can't obviously go to the court and say that the preamble is being violated and therefore a relief should be granted. But the role that something like the preamble plays is that it sets out what that path is in terms of principles and values, that then informs the interpretation of the rest of the constitution. So these ideas of liberty, of equality, and of fraternity, and human dignity, and all of these are principles or values that are at the base of the constitution. And what it means to be a constitutional republic is that the destination that we take is not separate from the path that has to be walked on to get to that destination. So I think that is I think the importance of really focusing on what the word constitution means, and the relevance of a document such as the preamble and what it says, because it might be easy to dismiss the preamble as being something external or extraneous that just has these grand words and doesn't really have any kind of meaning or significance to actual adjudication in legal cases. But I think that the role played by the preamble is in setting out that path that must be taken. Now, then, of course, the question is that what is that path, and there all these words in the preamble become really really important. because when you look at all these words like liberty and equality and dignity, so it's important to remember that these words did not just drop from the heaven one day. Each of these words has that we find in the Constitution's preamble has a certain history to it, and that's a history of long-standing struggles against injustice, struggles to achieve a certain kind of freedom and inclusion, as opposed to the old exclusionary order. And it's only in understanding the nature of that struggle that we can understand what these words mean and in what sense the preamble is inclusive, and why these words matter. So then, of course, the question is that what is this history of struggle that we are talking about? Now, there's one school of thought that denies to the Indian Constitution any, you know, character of this kind of inclusionary, transformative character. Uh, Now, this school of thought, which I don't agree with, this school of thought holds that the Indian Constitution is basically an instrument of continuity. It views the moment of constitutional framing as a simple transfer of power. So, this school of thought tells us that the Constituent Assembly, of course, was established under colonial British law. It tells us that 75% of the Constitution was lifted from the colonial 1935 Government of India Act, and most importantly, it tells us that many of the most repressive provisions from the colonial times, provisions for preventive detention, for emergency powers, many of the provisions that have been actually in controversy in recent times across the country, um, many of these were carried over lock, stock, and barrel into the new constitution. Now, in the Indian Constituent Assembly, there were those who rose to oppose this. There were those who warned that what the new constitution was doing was simply replicating the colonial structure. But their voices were not heard. They were told that was then and this is now, and that an elected government will never misuse this legal framework. And so all these provisions of preventive detention, emergency powers, so on, they were retained. And on the basis of these historical events, the argument goes that the constitution was an instrument of continuity, and this, of course, is not an academic dispute, because if we understand the constitution to be that instrument of continuity, then the preamble effectively doesn't matter at all. And many of the ongoing controversies around to what extent is preventive detention compatible with the constitution, and so on, would then be resolved in favor of the state. So that debate then becomes important, that what ultimately is the constitution trying to do, and what and where it's coming from. Now, my respectful view is that this continuity argument is a very narrow way of understanding constitutions and constitutionalism. It is my submission that we unduly restrict and constrict our vision of the Constitution if we limit ourselves just to that text and those specific debates that led to the framing and the political instruments that came before it, like the Karachi Resolution, for example. Because there is a much broader and much deeper history to the words that finally found their way into the Constitution via the preamble and the signposts I referred to earlier. And that is this history of struggle for justice and for freedom. So over the years, Indians responded to injustices, political, economic, social, by articulating a vocabulary of rights, freedom, equality, and dignity, all those words that ultimately ended up in the preamble. The great civil rights lawyer K.G. Karnabiran, the late K.G. Karnabiran, uh, he wrote in a passage in his book called The Wages of Impunity, where he summed up this idea very beautifully. So he wrote that a constitution framed after a liberation struggle or a struggle for independence is like poetry, emotion recollected in tranquility. There cannot be and there should not be two social histories, one for political theorizing and another for legal theorizing. The people who met in the Constituent Assembly were not mere technicians who had gathered there to prepare a handbook for running the government. They had participated in the struggle, and every effort had been made to give their gathering a representative character. So Kanabiran points out, therefore, that there is a social history that underlies the Constitution that is articulated in the preamble. And it's a history that goes beyond just the nationalist movement that is the dominant version of history. It's a history that one finds in very unexpected places. For example, in Bankim Chandra Chattopadhyay's Samya, which was a text from the 1870s, he talks about structural and institutional inequality on lines of caste, of gender, and economic class, far before these concepts became prevalent in Western academia 100 years later. You find it in how somebody like Ambedkar, who went on to become the principal draftsperson of the Constitution, articulated the idea of a right to public spaces during the Mahad Satyagraha and the temple entry movements. You also find it in someone like Motilal Nehru's speech to the Indian National Congress about executive overreach in 1921, when he says that the executive cannot engender a sweeping crackdown uh, that affects the whole society just because a few people, may be committing crimes. So the idea of proportionality comes in very early on. So so you have all these social histories that play into the broader history of the framing of the constitution. And I think that once you expand your gaze to this broader constitutional canon, you find that the constitution, as expressed through the preamble, those values, um, they were meant to be effectively transformative in two ways, um, that brought us from an exclusionary history to an inclusionary one. So, in the first sense, there was a political transformation. Under the old colonial regime, the Indian people were viewed by the British government as subjects to be governed, administered, and when required to be controlled. So they were excluded from any form of political participation um, in the governance of the country. So the first sense was that transformation to inclusiveness, to a republican democracy that viewed people as citizens, citizens who were entitled to demand accountability from the government, citizens who had rights against the government, right to free speech, association, movement, and so on. In South Africa, a country that endured a very similar transition from authoritarian rule to republican democracy, they have a specific word for this shift. They call it a shift from a culture of authority, where authority was answerable to none for what it did, to a culture of justification, where every state action that impacts citizens has to be justified to citizens. And they, in turn, have the right to disagree, to protest, and to challenge it in all the forums available to them. That, of course, is important in many different ways. And I know that we are operating under a situation of, for example, restricted internet usage right now. Something like that affects these kinds of rights, because whenever a utility like the internet is restricted, it obviously cuts off those channels of communication through which people can engage with or object to, or speak about decisions that have impacted their lives to a great degree. So that idea of um, uh, the constitution, and through its preamble, taking people from subjects to citizens, is one very important anchoring role that the preamble performs through its phrases like "we the people adopt, enact, and give to ourselves this constitution." So it's not a constitution that has been imposed from top down, but the people are meant to have a participatory role um, in the constitution and in governance, and that then flows into the fundamental rights chapter, free speech, association, and so on. So that was one way in which the constitution was transformative in this exclusionary to inclusive sense, and the role the preamble plays in that. But the constitution was also transformative, I think, in a deeper sense, and it sought to transform not only the relationship between the individual and the state, but also to transform society itself. Um, and this is because, unlike their counterparts in the West, who viewed the state as a monolithical institution and the single source of power that needed to be controlled, the framers of the Indian Constitution understood that apart from the state, social institutions and social structures could also impact freedom, equality, and dignity, those words in the preamble. So it wasn't the case that if you constrained the state and constrained state power, the residue that would be left over would be human freedom. That was the dominant way of thinking in constitutionalism. It still is in many countries like the US and America, but it's never been the dominant way of thinking in the Indian constitutional context. And so, as Ambedkar pointed out in 1946 in a note that he made on fundamental rights, he said that it was essential, therefore, also to pay attention to the way in which institutions such as caste, gender, family, and so on created those kinds of exclusionary hierarchies and these exclusionary power relationships, uh, and then to question and to interrogate these power relationships. So this ultimately became the constitutional project of inclusion was a project of democratization that went beyond just the public sphere where the state operates, domain of government, and addressed what we also think of as the private domain. So you apply this framework of rights and of inclusion and equality and dignity to private relations, private spaces, private institutions. This was contained in what we now define as the Constitution's horizontal rights provisions, that is, rights applicable between private parties and not the state. So, Article 17, for example, prohibits untouchability. Article 23 prohibits forced labor. Article 15, Clause 2 guarantees non discriminatory access to shops, restaurants, hotels. And if you look at this provision, Article 15, Clause 2 specifically, uh, you will find that it was essentially an anti boycott provision. It was meant to defeat the social boycott process through which large segments of society were repeatedly denied access to some of the basic goods and services that are necessary to sustain a decent life, and indeed were kept segregated physically, economically, culturally, and socially in order to keep them subordinated. So that is the, I think, the overall point I want to make about the role of the preamble, its historical place, and what inclusion means both in the political sense and in the social sense of democratization and equality. Um, but of course, ultimately, what is of interest is not so much as the theoretical speculations, but how this is applied in an actual case. So I thought that in the second half now of this of this interaction, I would talk about one case, I think, which really exemplifies the confluence of all these ideas that I've been talking about. And this is for me a really interesting case. It's fascinating, and it has a lot of stories that are attached to it. So the story of this case originally begins in the late 19th century, so the colonial times. In the 1880s, in fact, there was a young woman called Rukmabai, who at the age of 11 was married off to an elder man called Dadaji. This was in Maharashtra. Rukmabai's parents were dead, and she was brought up by her uncle who educated her. Uh, she did not live with Dadaji, and he never sought her out either. However, when Rukmabai turned 18 years old and stood to come into a substantial inheritance left to her by her parents, Dajaji suddenly woke up and realized that he was married. He had forgotten all these years. And so he asked Rukmabai to come and live with him. Rukmabai naturally refused to go and live with him. And at this, Dadaji went to court. Uh, and he invoked the restitution of conjugal rights. All of you would be familiar, very familiar with that provision. Ironically, the restitution of conjugal rights had no origin in Indian family law, in any branch of Indian family law. It was a colonial import that had been transplanted into Indian law through originating in the 1865 Matrimonial Causes Act in England. So it was a completely colonial alien imposition that was grafted on into Indian family law. As everyone knows, the restitution of conjugal rights requires that if one spouse has unreasonably withdrawn themselves from the company of the other spouse, then a court must pass a decree requiring the former to go back to the latter, hence restitution of conjugal rights. That's what the law says. Of course, now it's not enforced anymore, but in this way, but that's what the law said. And the courts determine whether the withdrawal is unreasonable or not. So Dadaji launched this proceeding, restitution of conjugal rights, and everyone thought that he would win the case because this is again the 1880s, and the rights of women were not specifically very something that was very prominent in the public sphere at that time. But Rukmabai defended herself in the court, and much to everyone's shock, she actually won the case. The single judge of the Bombay High Court, English judge called Justice Spinney, he held that he would not order this young woman to go to a house where she had been married into at a time at which she had been so young and effectively unable to provide any meaningful consent. So you can see here, 140 years ago, in a very incipient form, the first idea of why something like consent matters, why the individual matters, and why rights matter beyond just the state. It's not just about the individual and the state. But Justice Binney's judgment led to a massive backlash. It was argued that the English, with their Western notions of rights, were unduly interfering with the sacred domain of the family and of community values. It's an argument that we've heard recently as well. It's an argument that has been made, always gets made whenever gender rights really come to the fore. Yeah, and this argument is that the institutions like the family and the home and the community are immune from the civil law, from constitutional rights, from ideas of freedom and equality, because they belong to that private domain where the state's writ may not run. So that is how the argument goes. But perhaps for me, what is really fascinating is that this backlash that came to the judgment, it did not go completely uncontested. Indeed, the primary response was led by Rukmabai herself. In two anonymous letters that she wrote to the Times of India. Times of India was still in existence 140 years ago. Titled "Letters from a Hindu Lady," Rukmabai set out a really eloquent and impeccable argument for how marriage imposes very different obstacles and barriers upon women as opposed to men, based on uprooting their entire lives and going elsewhere and so on. Rukmabai, of course, did not possess the conceptual vocabulary that would be developed many years later by constitutional scholars, judges, and lawyers. But nonetheless, what we see in her letters is this very clear understanding and a clear articulation of the relationship between principles of equality and the institution of marriage, and how, coming back to the theme of inclusion, you need to include these domains of the family, gender relations, and so on into the framework of rights, of justice, and of equality. You can't keep them out and just let the power relations as they exist, keep ongoing over there. Rukmabai was supported by many prominent social reformers of her day, men and women both, who, drawing upon various writings, John Stuart Mill and so on, uh, articulated a language of rights, of freedom, and of inequality, and that applied within and against institutional structures such as the marriage and the family. You will not find these arguments in political philosophy textbooks, or law textbooks, which is where we are accustomed to looking for them. But you'll find them in memoirs, in letters, in records of public debate, in the newspaper debates, because it was in these forums where these whole ideas of inclusion, of equality, really sprung to life that would later come into the Indian Constitution. Uh, Ultimately, proved not to be enough because the appeals bench, the division bench of the Bombay High Court, reversed Justice Pinney's decision and held in favor of Dadaji, granted the decree for restitution of conjugal rights. Rukmabai then appealed to the Privy Council and to then Queen Victoria. But at this point, Dadaji realized that it wasn't worth all the effort, so he entered into a settlement with Rukmabai and dropped the case. And Rukmabai then went on to become one of the first trained female doctors of India. So the story had a happy ending, even though the case did not. But that's the first part of the story. Now you fast forward 100 years from the 1880s to the 1980s. And in the middle, of course, you have a freedom struggle and a constitution with the preamble we have talked about and was values we have talked about. That's the big difference. And this story brings us right to the Andhra Pradesh High Court in Hyderabad, where the case involved another young woman called Saritha, who at the age of 16 was married to a person called Venkat Subbiah. They did not live together, much like the previous story. And over the next 5 years, Saritha became a famous and popular actress. Uh, then Venkat Subbiah suddenly woke up one day and realized that he had been married for all these long years. And like Dadaji a century before him, he asked Saritha to come back and live with him. Um, and like Rukmabai, then Saritha refused. It's too late. And then, like Dadaji, Venkat Subbiah filed a suit for restitution of conjugal rights, the same provision that was invoked 100 years ago. And like Rukmabai, Saritha defended it. But here is where their paths diverged because Saritha had something that Rukmabai did not, which was the Indian constitution with its promises of freedom, of equality, and the values that were contained in the constitution's preamble. So Sarita argued for the first time in constitutional history that the provision allowing for the restitution of conjugal rights, which you may remember was a colonial implant which had no equivalent in Indian family law, was unconstitutional. Uh, she argued that it infringed upon her right to privacy and her right to take intimate and private decisions on her own without coercion either by the state or by any other private party or institution. And Justice Chaudhary of the Andhra Pradesh High Court agreed with her and struck down the provision as unconstitutional. Now, it's worthwhile to take a pause here and step back for a moment. If we think about how the concept of privacy evolved as a legal concept, starting in the US in the end of the 19th century, we find that it took two forms. The first was the privacy of spaces. Contained in the old chestnut man's home is his castle, the privacy of spaces held that there was something sacred or something morally important about spaces like the home. The home was the threshold beyond which the state could not come. And of course, what happened beyond the threshold, what happened inside the home, was nobody's business. The second form was the privacy of institutions or relationships. According to this second form, there was something morally important about relationships like the marriage or the family that had to be protected from state interference. For example, in the US, there was a law that prohibited married couples from using contraceptives. The US Supreme Court struck down this law on the basis that what happened within the marital relationship was not the state's concern. Another example is of the Irish Constitution, a document from which our own framers borrowed quite heavily. And this constitution the Irish Constitution, has an article that sets out the family as the fundamental unit of constitutional concern. But Sarita was articulating a very different idea of privacy, an idea that came into direct conflict with the privacy of spaces um, and the privacy of relationships. She was seeking privacy for herself, an individual, in and against these spaces of the home and the relationships of marriage. She was making an argument that Rukmabai had made a century ago, um, but now with the constitution on her side. And it was an argument that Justice Chaudhary found very compelling. He held that an individual did not lose their right to privacy on entering into the marital union. And the restitution of conjugal rights provision effectively transferred some of the most fundamental and intimate decisions and choices away from the individual and was therefore unconstitutional. Now, Sarita and Justice Chaudhary's arguments will, of course, be familiar to students of constitutional law because for decades, scholars and including feminist scholars have argued that privacy as traditionally understood is oblivious to all the inequalities and the power relations that exist within what we understand as private spaces and thereby end up perpetuating and entrenching those inequalities simply because they're not the state is not involved. So whether it is the caste inequality or religious inequality within religions or within the family, all of that is left untouched through this kind of privacy argument that the state can't interfere with communities, with social groups, with families, and so on. And that, of course, curtails how freedom and equality exist within those private spaces. So that was the argument that was accepted by the Andhra Pradesh High Court and by Justice Chaudhary. And as we can see, the argument had its origins far back in the 1880s in one woman's battle against restitution of conjugal rights, and then came to a fruition one century, one freedom struggle, and one constitution later. So that was how this story went, but unfortunately, it did not end here either. The same year, the Delhi High Court was also considering the same question, the constitutionality of the restitution of conjugal rights. And Delhi High Court came to the opposite conclusion. It upheld the provision. And what's most interesting is the language that it used. It observed that that cold constitutional law could not be allowed into the warmth of the home, and that doing so would be like bringing a bull into a china shop. This whole issue of cold and hot temperature differences aside, this is exactly the argument that was made 100 years ago before in the backlash that had taken place when Justice Spinney decided in Rukmabai's favor that the space of the home or the family or community or society has its own governing principles, its warmth fundamentally at odds with the coldness or the objectivity of law and constitutional rights. Um, and unfortunately, in my submission, unfortunately, a couple of years later, the Supreme Court, when called upon to resolve the conflict, sided with the Delhi High Court and also upheld the provision, although in more restrained language. But even that story is not over yet because, as we all know, 3 years ago in 2017, the nine-judge bench of the Supreme Court was asked to rule upon whether privacy was a fundamental right under the Indian Constitution. And in answering that question in the affirmative, the court also went into the question of what precisely was meant by the right to privacy. And it came down strongly on the side of privacy being an individual right and not a right accorded to spaces or to institutions. Um, the plurality judgment in that case, in fact, devoted 2 pages to discussing this critique of privacy of spaces and held that any conception of privacy must take into account and address the critique of how it intersects with gender equality and gender rights. So the time will tell if the future will see a different change. But that ultimately, in conclusion, really brings me back to this idea of the preamble and inclusion as a governing idea. And the point, the note I want to end on is that there were certain presumptions and assumptions about in colonial times about who had rights and against whom were these rights exercised. So in the colonial times, very few Indians had rights, and those rights were limited, very limited. Indians were subjects of the colonial regime. Uh, the British had more rights than the Indians did in India, um, and those rights were at the whim and the fancy of the British government often. Um, the Constitution is a project of inclusion via the preamble, in the sense that it seeks to bring more and more people, include more and more people into the ambit um, of rights, into the ambit of the values of freedom, equality, and dignity, uh, and to and through that inclusion also bring in other institutions that traditionally were excluded from the purview and domain of rights. So again, social groups, communities, caste groups, religious groups, the family, and so on. So the constitutional project of inclusion um, is one that understands that individuals must have rights both against the state, but also against these other non-state social structures that have an equally deleterious effect on the individual's ability to live a free, equal, and dignified life. Um, and the entire terrain of constitutional adjudication after independence has been a terrain caught between these two conflicting impulses of moving towards greater inclusion or moving towards exclusion. Uh, and in the conflicting judgments of the Andhra Pradesh and the Delhi High Court that I've just discussed, we see these two competing visions at play, one emancipatory, one regressive, one that interrogates power, one that preserves it, and one that seeks towards more inclusion, and one that goes toward exclusion. The Constitution is the terrain upon which these questions are debated in the courtroom, but it also goes beyond that in public debate, in our daily lives, in the institutions we participate in, and the relationships we have with others. And what I suggest is stories of Rukmabai and Sarita uh, point us to the direction in which we can understand the Constitution as an inclusive document, and the preamble's role in that inclusion, and answer and look at the signposts that I talked about in the beginning, to understand how the Constitution, in its inclusive sense, answers these questions. So with that, I will close, and if there is any discussion or anything of that kind, I'd be happy to engage in discussion after that. It's up to the organizers to decide.
Yes, thank you very much, Mr. Bhatia. Just first comment I have received from Mr. Raman Kukureja. He says that even though we had studied at college and worked at internships regarding restitution of conjugal rights and privacy law, but never went into the history of it. Your lecture is very enlightening. So
Yeah,
this
it's very
this
interesting
itself
because
shows that you have
people think
gone into the history of it. And
yeah,
yes,
because
please.
people think that restitution of conjugal rights is part of Hindu law. Actually, it came from the Matrimonial Causes Act in 1865 in the UK, and it was taken out in the UK, but it somehow persisted here. And it has been like a big history around it. From the 1880s, it's been constantly, contested back and forth in many cases, both before and after independence. So it's got a very long and very interesting history. And if you're interested, then just if you Google Rukmabai and read, there are lots of very good articles about her and about that court battle in the 1880s, in the Bombay High Court. It's very interesting. I would recommend, if you have some free time. It's just a very interesting story.
Thank you. I stand corrected. It is Miss Raman Kukreja. Yes. Uh, there is another question in the Q&A box. The question is from our participant, Miss is Tajammul Islam. The question is, in the recent times, we have been talking a lot about death of democracy. So, in the present Indian context, why this phrase is being used and uh, what actually it means, why it is so important in the recent years.
So I think that it could mean many things, but it ultimately comes down to how you understand democracy as a concept, and of course, that is something that will can we can go on about that for a full year and still not get closer to understanding it. So I think that in the sense that it's presently used around the world, is that societies and in fact constitution, including the Indian constitution, have this kind of conflicting impulse. One impulse is towards centralization of power. So that the power should be concentrated in a centralized fashion within a few hands in the interests of efficiency and decision making and so on. And on the other hand, there is an impulse towards decentralizing power in the interest of distributing it between various bodies. So federalism, for example, is a fundamental impulse towards decentralizing and distributing power. Similarly, the existence of different independent bodies, including the judiciary and other what they call fourth branch institutions, like the Information Commission, Election Commission, and so on, is a step towards distributing power in various bodies, so that no one individual or no one body can have all the power. And I think that's kind of like all constitutions across the world have these kind of two impulses, and at any given time, one is dominant over the other. And I think that the critique of late, whether you look at Poland or Hungary or Turkey or the US or India or in the UK, the critique is that we are seeing a shift, a time in which the shift is towards centralizing of power as opposed to decentralizing it. And that ultimately will cause problems for democracy, because democracy only thrives when no one body can dominate over the others. So I think that's the sense. It's a question of whether the institutions that are responsible for uh, distributing power over different bodies and not concentrating it, if they are functioning well or not. So I think that is what the thing is.
Thank you. This question is from Mr. Kamlesh Pandita, our district and sessions judge. Uh, is not it the right time to make fundamental duties enforceable like fundamental rights to balance the space?
So there are already the constitution already provides for the situations under which rights can be restricted, and there are these every right is accompanied by a restriction that sets out the specific situations under which those rights can be restricted, and you have judicial doctrines like proportionality that adjudicate between when the right prevails and when the restriction is reasonable. So I think that the constitutional structure already exists to draw that balance. I think that the risk with making fundamental duties enforceable is, first of all, we don't know what form those duties will take. But secondly, again, the risk is that there are invariably they are framed in vague and open-ended ways that then allow for very variable interpretation of what they might entail in practice, which is always a risk. I think ultimately, I think it's a question about human nature, is that you can't force people to be good, or to do the right thing. It has to come from inside, or it has to come from persuasion. But if you try and force people to go a certain way, then human nature is not designed to work that way. So I think that the fundamental duties being enforceable might risk counterproductive results, where once people think they're being compelled, to go a certain way, then it just leads to conflict that otherwise is avoidable. But I think the main reason is that the constitutional structure at present has that balance already inbuilt into it. So we don't need to add another layer into that.
Thank you. There are two questions from Anna Anupriya, a law intern. So you have said that individuals, as a result of the Constitution, have rights against non-state social institutions as well. Can you elaborate on that with respect to the institution of religion? And the connected question is specifically the struggle between Part 3 and the personal laws.
Yeah, that's again a complex question that would take hours to properly
Very good
answer.
questions, Gautam.
Yeah,
Very
yeah,
good questions. What is
yeah.
Rajiv Anupriya is from where? Which university? And what year student? Please ask
That
her.
that is not mentioned. Probably
You
we
ask
can
her, ask her, she
yes,
will tell
yes, we
you.
can probably we can take the line turn on board. I'll just try and specifically the person would introduce in just a minute. I'll get the person on board.
Hello.
Yes, now I would
Good
request
evening,
Anna
ma'am. Good evening.
Anupriya to please introduce yourself and ask your question in your own words.
Good evening, ladyship. Good evening, sir. Good evening, Mr. Bhatia. Uh, sir, can I
Yeah.
repeat my question?
No,
Yeah, go
first
ahead.
tell us, introduce yourself, Anu. You're from which university? Which year are you in?
Ma'am, I'm in the fifth year, BA LLB at Law College, Dehradun.
Very good. Very good questions, Anu. I'm impressed. Please go ahead.
Thank you very much, ma'am.
We can't see you. Turn on your video. Are you a Dunite or are you from another part of the country?
No, ma'am, I'm from Jharkhand actually, but I have been to Dehradun only for the law degree.
Are you from Ranchi?
No, ma'am, a little bit away from Ranchi. It's a small town called Godda.
Very good. Yes, please ask your question to Gautam.
Sir, my question was that you said that after the constitution has been enacted and enforced, the element of inclusivity has increased, and now we don't only have rights against the state, but also non-state institutions. So one such institution is religion, and there has been a struggle between the interpretation of personal laws with respect to Part 3 of the Constitution, specifically after the Tipu Talaq judgment was given by the Supreme Court. So what are your views on that?
Yeah, so as I said, this is a very complex question, and I think to answer it in full would take many hours. So I'll try and give a brief response. So the story begins with the Narsu Ali judgment in 1952, as I'm sure you've read, when the Bombay High Court held that personal laws are not subject to Part 3 of the Constitution, which in my view was a wrong judgment and should be overruled. Um, uh, and the reasoning of that judgment was quite flawed. So my own view is that personal laws, whether codified or uncodified, is should be subjected to Part 3 of the Constitution. And your question comes into play when you have uncodified personal laws, because if it's codified personal law, then it becomes a state act, right? So then it's again a question of individual against the state. So it's uncodified. I think that it's really important there um, because we need to remember that personal laws, just like any other sets of laws, are always the creation of human beings. They don't come down from the heaven fully formed. And specifically in the case of gender, if you go into the history, you will see that invariably these personal laws in long periods of history have evolved in ways in which women have had little to no say in what form or shape they took, even though they fundamentally affect women's rights. Triple talaq is an example, and examples from every personal law, just like they're full of them. There was a recent Parsi case as well, Golrukh Gupta, which is pending, about Parsi women's rights to enter fire temples if they marry outside the religion. So there are all kinds of these rules that affect women's rights if women had no say in like actually giving shape or form to. I think that's why it's really important to ensure that the idea of rights, the idea of freedom and equality is something that applies not just to state law, but also to non-state uncodified personal law. Now, I think also that this specific debate has now become somewhat it no longer has the bite that it once did, because after a triple talaq judgment, it's now been held that Muslim personal law it flows from the 1939 Shariat Act, and Hindu law is anyway already codified. So you are now in a situation where pretty much by interpretation, most personal law is now codified. So now the state, it's a state law. So now it's come back into the domain of the state. I think where you might see in the future the controversy the controversy is coming in is the relationship between Article 25 and 26 of the Constitution, where the rights of denominations often clash with the rights of individuals. And so you might see cases where this whole essential religious practices test comes into play, and if within denominations or within religious groups there are practices that may not be codified personal law, but maybe other kinds of practices, like the Haji Ali Dargah case involving rights of women to access Haji Ali Dargah, Sabrimala case involving rights of women to access Sabrimala temple. So all those cases are not personal law cases, but they still involve practices within religious groups that in certain ways affect gender equality. Right? And so I think that going forward, I think the question of whether women have rights and to what extent women have rights against community norms, right, will become maybe I think important in these kinds of cases more than personal law cases. But that's just my guess. I don't know how the future will unfold, but I think that's the domain in which it'll be. You'll see cases and controversies, and not so much in personal law, because now it's all codified, and the challenge is now to state. And you say you have a uniform civil code, that will also be a state law. So then again, it'll be an individual versus state issue over there as well.
Thank you very much. This is a question from Mr. Muzammil, a judicial officer from Jammu and Kashmir. Do you see any change in interpretation of the constitutions around the world favoring
Rajiv, just 1 minute.
exclusive? Yes, ma'am. Ma'am, you are on mute, ma'am.
Is Anupriya
Yes,
still connected?
Yes, ma'am.
Anupriya, please switch on your video.
Yes, ma'am.
This is just one question. What do you propose to do with your law degree?
Ma'am, actually, initially I wanted to study further, and just like our honorable panelists today, I wanted to get a little more educated in the field of law, and then eventually uh, write books and that sort of stuff. But now that my plans have changed a little bit, I wish to appear for the UPSC examinations.
I was hoping you would say you want to do the civil services. God bless you and all the best. You can still study a little more and then take the UPSC. Don't be in a hurry. You're on the right track.
Yes, ma'am. Thank you.
Follow Gautam. You follow Gautam Bhatia. Study a little more. Are you a first generation law student? Are you a first generation law student?
No, ma'am. My father is a lawyer. Is a criminal lawyer in the district court here.
I see. He's practicing criminal law. Criminal lawyer is a dubious expression. But good luck to you. You know, I would love to follow your career graph. Carry on, Rajiv.
Thank you so much, ma'am.
Thank you, ma'am. The question was, do you see any change in the interpretations of the constitutions around the world favoring exclusive rather than inclusive doctrines?
I think it depends. So as I said, there are these two impulses that are present. Are present in all constitutions, and it depends on the time and the place. So if you look at right now what's happening in a country like Poland, or in Poland, just like 2 weeks ago, the Supreme Court had a very exclusionary and restrictive judgment on abortion rights, and there have been mass protests in the streets after that. In Turkey, that whole Hagia Sophia judgment, which you would have seen, there's that. In the US now, the court is very politicized. It's dominated by by judges who have very exclusionary readings of the constitution. So there's that one set of countries. On the other hand, just 2 days ago, no, just 5 days ago, the South African Constitutional Court had a wonderful judgment where it said that you can't exclude domestic workers from the social security law, because in South Africa, social security law, labor law, excluded domestic workers from its ambit. And the Supreme Court then interpreted the law to include domestic workers, saying that we must recognize the dignity of domestic work, and that it's real work, and you can't just exclude it from social security benefits. And in Canada, last month, there was a good judgment on indirect discrimination on gender. So in some countries like South Africa, like Canada, you're moving towards a more inclusionary interpretations of constitutional rights. Other countries like Poland and Hungary and the US, you're moving towards more exclusionary interpretations. And it is just like these are pendulums, they swing from side to side, and it's just, I think, as for me at least, as a lawyer, and it's important to keep trying to argue for and advocate for a more inclusionary reading at all times, and not the exclusionary reading.
Gautam, this was a very good question. The question, I think Balajyoti asked this, Rajiv. Balajyoti is a judge with us, and I'm very happy. I think
She
there's
has
pressure going off in the background. Every time I keep muting my mic so that you don't get to hear the cooker. But this must be a familiar sound for you, Gautam. Music for the ears after a long time. But
Yeah.
the question was, this my house is such that the kitchen is too close to where I'm sitting to anywhere else. But the question that she asked was constitutions which are exclusionary. So your answer would show that the constitutions may be having inclusive provisions, but it is the interpretation by the courts. That is to say, judges are getting regressive, and more and more, there are more and more judgments from more and more courts making the reading the constitution in an exclusive manner. And the Constitution Court of the South Africa has always been such an inclusive court. Gautam, tell people about the architecture of that court. I happened to visit it and I met some of the judges, but
Yeah.
it's phenomenal. I'm sure you can tell them better than I would.
It's very interesting. So there are many different facets about it. The first facet is that it's built over the old jail that used to be, and I think Gandhi was also at some one point in that jail. So it's built over a jail to kind of signify the transition that took place, and that to never forget the history that was there, and what it meant to break with. Second thing is that the actual courtroom is where. So if you look at the structure of it, it's in three levels. At the lowest level are the lawyers who are arguing, at the dais. Above them are the judges, but above judges are the people. So the audience in the Constitutional Court of South Africa, the people watching the proceedings, their seats are at a level above the judges. So the idea being that the judges are always, serving the people and serving the country, and not above the people. So the judges are looking up at the people, and the people looking down at the judges. So they have that architecture that is very interesting. And the lawyers are like lowest down, so they're looking up at everyone. And also inside there's a lot. It's very well lit, a lot of light in the court. And if you go down the corridor, I was there a few years ago. You find all kinds of sculptures of a very absurdist character. There's one big dinosaur over there as well, and that is Justice Albie Sachs, He was the legendary justice who lost both his arms in a years. When he was a lawyer, they tried to the extremists tried to kill him because he was taking up all these civil rights cases. He lost both his arms, and then he became a constitutional court judge after apartheid ended. So he said that judges should never lose their sense of humor. So whenever they are walking in the court, they should see all these sculptures, funny sculptures, dinosaurs, and so on, and remember that it's always good to keep a sense of humor at all times. There are two or three of the things that really make that courtroom quite special, and it's very interesting to visit that court.
The bottom one side of the court, the judges are at the bottom, the lawyers. It's like an amphitheater, and
Yeah.
one side of the court is glass windows,
Yeah.
and
Yeah.
and those windows are at eye level with the road outside, and
Exactly.
the judges, and that was to remind the judges constantly of the people who are there, who they are there to serve. It's a very humanizing court. They have
Yeah.
used bricks from the old prison inside the courtroom. In fact, you can see the brick wall of the prisons, which to constantly remind them, and to which makes them all very liberal in their thinking. In fact, it's a constant reminder. It's a very right-based court, and the thinking is extremely inclusive and very wide. You see the best enforcement of and best judgments ensuring equality and removing discrimination. Yes, Rajiv, please go ahead.
Yes, this next question is from Ajaz Loan wanting to ask question himself. I'm unmuting Mr. Ajaz Loan to ask question. Yes, Mr. Ajaz Loan, ask you a question.
Sir, am I audible, sir?
Yes, please. Very much.
Thank you very much, Honorable the Chief Justice, for inviting Mr. Bhatia to this event. It is an honor to.
Video,
My
Rajiv.
lords cannot hear, my lords.
No, switch on your video.
Actually, he has joined with his two systems, so I can take him on board with video.
Ask him to just, okay.
Yes.
My lords, I was just thanking my lords for inviting Mr. Bhatia, and my lords, I just want to ask something to Mr. Bhatia. Today, in a constitution-based speech, Honorable Mr. Justice D.Y. Chandrachud, who incidentally reads Mr. Bhatia's blogs also, as he has mentioned in one of his cases. And he says, in cases and controversies brought to the court, evidencing a deprivation of constitutional and legal rights, the Supreme Court of India has not just the power but the mandate to interfere. So I would like to ask Mr. Bhatia that in cases where personal liberty of an individual and the social or religious practices are pitted against each other, the role of the constitutional courts is tremendous. So, do you think our constitutional courts, the high courts and the Supreme Court of India, are going to the roots of these issues? Because it is finally the law laid down by these constitutional courts which would be finally affecting and regulating the lives of the individuals. So, your views on that, sir?
Yeah, no, I think that the high courts and the Supreme Court have a very important role. But I think that what often gets missed is that the trial court's role is equally, if not more, important, because the trial courts are the first line of defense of the Constitution and of constitutional values. So the high courts and the Supreme Court interpret the law and set down the law, but on a case-to-case basis, the application of that in just basic things like in cases I've seen about whether the police application for remand or police custody should be accepted. Each time there's an application, is it just a rubber stamped judicial custody? Should it be granted automatically? So these are all questions that implicate constitutional rights and constitutional values, but we don't often think about the importance of the trial courts in defending those constitutional values. So I think that it's at all levels in different ways. the task of defending constitutional values and just treating the state's claims with some skepticism and some kind of rigorous scrutiny of the state is important at all levels, from the trial court level to the Supreme Court level.
Thank you.
I'd just like to add here, sir, Gautam, Ijaz Loan is a judge with us, isn't he, Rajiv?
No, my lords, I am Deputy Advocate General.
I see. So you're joining from Jammu or Srinagar?
No, my lords, from Jammu itself. I'm
Ijaz, who represents
Forest
Department.
Yes.
Very good question. Gautam, he's a High Court lawyer who works for the government, and the constant challenge that Ijaz and that you must always be facing is the Article 21 rights and environment law. You're constantly, you're having to give up in the light of when you're constantly balancing. What is
Yes.
Constantly having to balance Ijaz. I thought you were a judge, so I was very impressed. Because judges are constantly having to work. There's several areas. For instance, Gautam, when I was writing the court fees judgment, revenue versus access to justice, there's constantly, and then the disproportionate impact of a law like court fee on an entry point fee on the rights of people to access courts and the disproportionate impact thereof on women. Even that law is so gendered. So these are constant struggles, Ajaz, that we as judges constantly make. Lawyers don't have it so difficult, but the task of the judge here is very, very important.
Yes, my lords. That's why I asked, my lords. That's why I asked.
It's a constant struggle. You'll see this, you see your building bylaws. There also you're balancing people's right to property. It used to be a fundamental right.
Yes,
Some
yes.
of the lawyers and judges still like to argue it's a fundamental right to property against building bylaws. You
Yes.
can't build 100% on the plot. Or why can't I build a cinema hall in a residential area? Or why can't I have a liquor vent next to a school? Or next to a temple, or why can't there be a person selling beef or meat next to a temple? Then the business of using loudspeakers by religious institutions and
Yes.
you know that your azan in the morning and afternoon and
Yes.
constant in all these issues you're balancing fundamental rights vis-a-vis
The religious practices. Yes, ma'am.
other rights, religious practices, environment,
Yes.
rights. Then you're balancing rights, two conflicting rights of people.
Yes.
I remember having to argue a case where a sewage treatment plant was being built inside a water body.
Yes.
So, there you had to balance. There were two conflicting claims, two conflicting interests of environment, both for environment. The STP was required by the environment and for environmental concerns. The water body was equally important. So, these are struggles which judges have to live with, and lawyers have a challenging task. Well, interesting task, raising arguments, enforcing either. Go ahead, Rajiv.
Thank you, my lords. Thank you, my lords, for your intervention.
Yes, thank you, ma'am. Now this next question is from La intern Prashant Pratyar. I'll try to take Prashant on board to ask question. Yes, Prashant, you can ask your question. Yes, Prashant, we can hear you. You can ask question. Okay.
Good evening, sir. Can you hear me?
Yes, please
Yeah.
go ahead.
Good evening, Geeta ma'am, and good evening, Mr. Bhatia. My question is, with the idea of inclusion, why don't we do away with the protective discrimination in the form of privileges which are mainly used by power-hungry politicians?
I can't hear you.
Mr. Prashant, could you repeat your question? We are not able to hear it properly.
Oh, all right. With the idea of inclusion, why don't we do away with the protective discrimination in the form of privileges which are mainly used by the power
In the form of
in the form of privileges,
privileges.
right?
Right. Go on. Okay.
As in, we can see with the Article 105 of the Constitution of India, also we can see the reservation system, and also we can see other privileges which are granted under the Constitution. So,
You mean
don't you think that is
parliamentary privileges? Parliamentary privileges.
right?
Right. Right. No, I mean, so I see parliamentary privileges have. So I think privileges is kind of a misnomer here, um, uh, because it comes from this old colonial kind of like term. But actually, it's more in the sense that proceeding, because parliament is kind of the supreme democratic space in the country. What happens inside of parliament is for parliament to decide. So that privilege actually is in that sense. It's that external bodies cannot interfere with the functioning of parliament, because parliament is a democratic body. But actually, I mean, see, that is also pretty much now on its way out, because with the recent 5-judge bench judgment on money bills that doubted the Aadhaar case and so on, it now seems that the speaker's decision to certify money bills would be open to a judicial review, in my belief, rightly so. And in many of the recent controversies over government formation, you also find that the decisions of the speaker and so on are coming under judicial scrutiny. So I think that in any case, pretty much, I mean, Article 105 and those privileges, are going to gradually be phased out in any case, because they will be subjected to judicial review, the speaker's decisions and so on, of course, under the relaxed threshold. So I think that gradually, like that is going to be phased out anyway.
Thank you, sir. Now, next question is from Miss Bala Jyoti. She's our judicial officer. I'll just try to take her on board so that she can ask question. Yes, ma'am, you can ask your question. Madam Bala Jyoti, you can ask your question. Okay. Her question is in the chat box also. I'll read the question. While talking about rights, there are corresponding duties also, but it is astonishing that we often forget our duties to preserve the desired purpose of preamble. How can we ensure to enforce our fundamental duties too in total?
See, I think I said before, I don't think you can enforce a duty. If you can't force people to behave in a certain way. If you force people to behave in a certain way, then like, if people are doing things under compulsion, they're not doing it genuinely, and you can make it last for a while, but you can't make it last beyond the point. Um, the, um, the purpose of a constitution is to protect people from abuse of power that powerful institutions or powerful bodies like the state or other powerful bodies have. That is the constitution's role. The constitution cannot make people into good people, right? Law can't do that. Law can't turn people into good people. That has to come from sources beyond the law. And as I said, persuasion, conversation, talking to people, and so on. But if you go with a stick and try to beat into people that they have to perform their duties, uh, it's not. His history has shown that doesn't work beyond a point. I think that what is important is that in the interests of equality and dignity and of all, there are some restrictions on rights, and there are various laws like hate speech laws and so on that try to ensure that the exercise of everyone's rights can be protected in a way that one person exercising their rights does not impinge upon others' rights. So to that extent, you can have constitutional principles and laws that balance those competing values. But I don't think, in my opinion, you can't really force people to do their duty, because duties are not something that can be forced. They have to come from conviction, which is a function of society, how well balanced it is, and things like that.
Thank you, sir. This next question is from a law intern, Bhavesh Bhushan. As an advocate of transformative vision of the Indian Constitution, which is value-laden and not value-neutral, would you argue that the right to freedom of speech and expression is not wide enough as to allow a citizen to argue against the transformative constitutional values themselves? For example, to justify caste practices, defend the idea of race, vouch the supremacy of particular religion, etc.
No, I think this question is hard to answer in the abstract. It depends on the case and the context. So, for example, hate speech laws exist in all countries. Apart from the US, they exist in all countries. And the purpose of hate speech laws is not that you are arguing against constitutional values, but that the result of hate speech is that the groups who are targeted by that hate speech are put in a position where they cannot exercise their equal rights to live in dignity and without discrimination or persecution. Similarly, in Germany, you have the concept of militant democracy, where if a political party is contesting elections but does not commit to democracy in its manifesto, then that party can be dissolved, right? So it's more a question of, you look at it on a case to case basis and say that, okay, in this case, is the freedom of speech, is the result of it going to be to undermine other important constitutional values, and then you decide on regulation. So it's not that you can't argue against X, Y, Z, A, B, C. It is whether the exercise of that speech or that particular kind of speech, like hate speech, will result in the undermining of equally important constitutional values. And if that happens, then that kind of speech can be curtailed and regulated.
Thank you very much. This is last question from a law intern, Toiba Qureshi. I'll try to get Toiba on board. I'm unmuting Toiba. You can ask your question.
Good evening. Hello.
Please ask your question.
Yes, sir. Good evening to everyone. In your view, sir, is there lacunas in law, or the main issue is in the execution of the laws, the constitution, or is proper execution of law? What are your views on the question? What are your views exactly on the point?
Sorry, I
Hello?
didn't.
दोबारा से
Sir,
पूछिए
I'm trying to ask. Hello.
Please ask again.
So what are your views on is there problem in law, or the law is well and good but the execution is weak in its work? And further, the community accepting the laws and properly acting on it? What are your views on it?
Which laws are we referring to?
No, I'm just talking generally.
संतु बिठाना
It's hard to answer in general, right? Like some laws are problematic laws, and laws in which the implementation is an issue. So, like it exists in any society, across the board. So, it really depends on which law it is.
Rajiv, yes.
There seems to be some issue at participants' end. We'll take next question.
I can't. I think there's some interference. I can't.
Yes,
I
yes.
can't. I think there's some interference. I can't.
Toiba? She's got
Hello?
Saiba, where are you joining from? आप कहाँ पर?
Where are you joining from? आप कहाँ पर?
I'm from Kashmir Law College, ma'am. From Srinagar.
अभी किधर? श्रीनगर
अभी
हो?
किधर? श्रीनगर हो?
Yes, ma'am.
आप which law are you talking about?
Which
Would you
law
like
are you talking
to
about?
touch?
How would you like wanting to touch?
I was talking generally, ma'am. Ma'am, we always say the law is not proper, the law is not proper. I was asking the views of sir that is there any problem in law, or that is only the problem in execution and the mindset of people?
Implementation.
Implementation.
I thought it's a
Yes,
general
ma'am.
question.
It's a general
Take
question.
it like that, please
Like
answer.
that, please
I
answer.
said some laws, like in my view, like law of tradition or like PPA, those laws in my view are problematic in terms of law itself. There are other laws, various other provisions of the penal code or contract act which are actually abused or misused. So I think that it really depends on the case.
Thank you. Rajiv?
Thank you. We have law researcher Megha Anand. She wants to ask a question. I'm unmuting Megha. Yes, please ask your question, Megha.
Tell her to switch on her video.
Hello, good evening, sir. Am I audible?
We
Yeah.
want to
Yes.
see you also, Megha Anand.
Just a minute.
Uh,
I'll
Sorry,
try to get
extremely
her on
sorry.
board.
Yeah, yes, sir. That would be great.
Where are you from, Megha? Which law college?
Ma'am, I was your research assistant few months back.
In Kashmir.
No, ma'am, at Jammu.
Oh, I see. How are you, Megha? All well?
I'm good, ma'am. I'm good.
You can unmute your. Yes, your video is visible.
Yes, I
Please.
remember. She's a very bright child, Gautam, a very good lawyer.
Thank you, ma'am.
Pucho, Megha, please ask.
Sir, I wanted to ask you, during my GNLU time, we were reading constitutional law, and there was a special workshop as to the economic aspects of the constitution. So can you throw light upon the same, taking into some consideration the Consumer Protection Act of 2019?
Sorry, I haven't studied that act, so I'm not really in a position to
But in
provide a
a
view on
general
that.
sense, if of course, is there any economic aspects of the constitution,
Economic aspects, as in again, question
like
has to be a
a
little more.
particular article we can be taken into consideration? Like
I think
we reading that constitution always uphold the socio-economic values. So what kind of economic values can be taken while reading the constitution?
Well, I mean, you have Article 23, that's prohibition of forced labor, and the Supreme Court in PUDR's case has read a right to a minimum wage as part of that right. So you have that idea of basic like economic security, and and directive principles of state policy have important labor rights and labor protections, that are there. So I think that broadly it's a social democratic constitution that ensures that the economically weaker sections have protections and rights that prevent the exploitation by people who control levers of economic power.
But certain lot of judgments of the Supreme Court, Megha, have very deep economic impacts.
Yes, ma'am.
That has
Yeah.
been a debate, but it's a whole topic by itself. We need to do that as a whole session. You know,
Yeah,
Yes, ma'am, I understand.
there's several judgments which have had
That will be all, sir.
the
That
mining
that will be all.
areas and all those areas. There are deep economic repercussions.
Yes, ma'am. Exactly. Yes, it will. Everything would
Where
cover.
environment, constitutional rights versus environment laws versus economic impact. The whole business, whole debate about the definition of meaning of development.
Exactly, ma'am. Definitely.
You'll get judgments in the environment law areas on that if you want to see.
Yes. Yes, ma'am. Sure.
Yes. Rajiv,
Thank
I
you.
think we've taken
Yes,
a lot
yes,
of time.
ma'am. Just we'll take a last question from Rahul Kumar Kumawat.
That's
The
the
question
third
is,
time. That's
sir,
same quote, very, very last opportunity. Last opportunity to file a counter. Very, very last opportunity in the interest of justice. Very, very, very last.
sir, do you think it is time now to increase the ambit of Article 19, that is right to freedom of speech and expression, by removing restrictions under Article 19, Clause 2?
No, I mean, see, in no country is freedom of speech absolute right. So you always need to have provisions like hate speech, that provide protection from the effects of speech to vulnerable groups, and so on. So I think that you can't do away with restrictions, but they have to be interpreted in a narrow fashion, and always keeping in mind that it's not that it's not unpopular speech or offensive speech that has to be restricted, but only speech that actually harms constitutional values. So I think that is the key thing.
So thank you very much, Mr. Bhatia. You have talked about deeper philosophy of the Constitution in a short period of time. Yes, it needs more time to understand that philosophy. So maybe we can have more sessions on it
Yes,
in
yes, for
future.
sure.
So we would be requesting you for that. So thank you
Sure,
very
happy.
much. Our participants have always been eager to hear Ma'am Chief Justice. So they have been requesting me to request Ma'am
Gautam,
Chief Justice
I
to
was myself
say more. Yes,
I was
ma'am.
myself really looking forward to hearing Gautam. I read him all the time, and he has commented both favorably and adversely on my judgments. So, and I've learned a lot from whatever he has said. So, thank you very much, Gautam. Gautam, for all of your information, is presently doing his doctorate at Oxford, and he has very kindly agreed and done this program for us. He's had a very, very busy day. He began very early in his morning. I think you did the Constitution Day lecture for which institution?
Manipur State Legal Services Authority. It
Oh,
began
so
at 6
you really traveled across the country today.
I was telling my friend that I've done full Bharat Darshan today, like from Manipur to JNK in the space
And
of a
then I
day.
go to Jharkhand, but don't you find it absolutely incredible that children today are so evolved? I was very impressed with some of the questions. They were certainly, we weren't thinking like this when we were law students. I'm sure you did
Definitely.
when you were, but coming from places as far off as these children are, it's very, very heartening. So thank you very much. Really appreciate your time. Won't take any more of that. And
Thank you so much for calling me. It was a wonderful and rewarding session. Thank you so much.
I'm only 5 days away. I have only 5 more working days as a judge left. So I retire on 8th of December.
Okay.
So, and all the best in your work. I'll be in touch with you and take the benefit of your mind many, many more times. Thank you,
Thank
Rajiv. You were a wonderful host. God bless you.
Thank
All
you
the
very much, ma'am. To all the participants, especially to the line turns, I'll just tell that Mr. Bhatia would be with us in 2 days. We'll be having that session on career in constitutional law. So, with eminent
please,
speakers, Mr. Bhatia would be moderating that session. It
please
is
tell them
on
who the speakers
Saturday.
are. You will be having Parag Tripathi and Sham Devan. And I hope all of you will join. Gautam, we've had a wonderful participation. When 15 minutes into your program, people were, when you were, your joining got delayed a little bit. There were so many queries that we received as to what is the matter. And within 5-10 minutes of your joining, we were up to 215.
Oh,
So
wow.
we'll get the final count later on. So this
Oh,
is
wow.
how much your popularity is. You
Thank
better
you.
better return to India and get into business. God
Thank you so much.
So,
bless.
thank you very much. With this, we conclude this program and hope to see you all on Saturday in that interesting program on careers in constitutional law. So thank you very much. Thank you all.
Thank you so much.